My name is Bill Maurer. I represent the petitioners in the case, and I argued for the court, argued the case for the petitioners this morning.
Hi, I'm Nick Dranius with the Goldwater Institute. I represent also some petitioners in the case, and I was a note passer in this argument.
So I thought the argument went very well. There seemed to be some very significant concerns about the nature of this law indicated by the justices. I think they recognize that this is an attempt by the state of Arizona to insert itself into elections and place its thumbs firmly on the scales of publicly financed candidates. It is an attempt to interfere with the people's ability to choose who their leaders are. And it is a clear attempt to suppress the speech of independent expenditure groups and privately financed candidates in the state of Arizona.
When the Goldwater Institute brought this case in August of 2008, we knew that this law was meant to manipulate electoral opportunities and to level the playing field in favor of government-funded candidates. And it seems clear today from the court's decision or questioning and from its presentation that the court understands the incredible risk that is posed by an electoral system that would engage the government as such a power player.
My name is Dean Martin. I'm a former state treasurer of Arizona and candidate for governor. And I think what we saw today was the court expressing the First Amendment is not about providing government subsidies for candidates. It's about making sure that you have free and equal access. And then I think what we saw in these arguments today was very clear that when the government gets involved in the campaigns and tries to subsidize speech, it's no longer free. And I think that the argument that this is somehow eliminating corruption was completely unproven here, because in reality what it's done is it's provided a cloak of government approval on the same special interests that already exist in politics. They simply hide behind a government subsidy as opposed to being out in front through full disclosure.
Good morning. I'm Arizona State Senator Rick Murphy, one of the plaintiffs in the case. And one of the things that became clear in the arguments this morning is that the justices recognize that the First Amendment is not about protecting free speech, it's about protecting freedom of speech. And those are two distinctly different things. For the government to come in and put its fingers on the scales and tip the balance in favor of publicly financed candidates and disincentivize both fundraising and speech by traditional candidates is just not acceptable, and it is a thing that it really damages the speech and the freedom of the participating candidates, and it also makes it impossible for voters to get unfettered information without the government filter. Thank you.
Steve Voeller, president of the Arizona Free Enterprise Club. I think it was clear from the questions and the answers that for independent groups that spend a certain amount of money could trigger 2, 3, 4, 5 times amount to the political opposition is clearly a burden on speech and overly restrictive. Thank you.
Are there any questions for questions?
What questioning by the justices made you feel the way you feel in this matter?
Well, not necessarily. I mean, the way I feel is that I think that they recognize that there are substantial problems with Arizona's system under the First Amendment. And what indicated that to me was that so many of them had a problem with the idea that the Arizona system exists to level the political playing field. In our country, it is the voters, it is candidates, it is independent groups who get to decide who gets elected. It's not the government's place to be inserting itself into a campaign and manipulating campaign financing decisions in order to benefit its preferred candidates, in this instance, publicly financed candidates. So I think that a number of questions I heard were very, very suspicious and concerning about that.
If I may just add, the court said in Davis versus FEC that it's very dangerous business for the government to be engaged in the business of equalizing electoral opportunities. And the fact that the Arizona Clean Elections Act has never been justified as being anti-corruptive in its purpose until after Davis came down and made it clear that you can't level the playing field if you're the government. The fact that the court was honing in on that very basic factual point that even to this day, there's no mention of an anti-corruptive purpose on the Clean Elections website, and it still says its purpose is to level the playing field. That to me shows that the court is not in any way being misled by the arguments on the respondent side.
Respond to Justice Breyer's observation that what we saw today in other campaign finance cases is the death by 1,000 cuts of McCain-Feingold.
Well, McCain-Feingold has no relevance to this particular case. There is no public financing system like this at the federal level. There are some state systems that are like this. And I think what Justice Breyer was recognizing is that, there has to be a recognition of core principles at some point. And the question is, do you draw those core principles where the court drew them in Citizens United and Davis versus FEC, which is that freedom of speech is not subject to government policy. That we get to make the decision of how much to speak, when to speak, and under what conditions to speak.
I think there was also in Justice Ginsburg, just from the outset of questioning, seemed to outline how could Clean Elections as an organization continue after matching funds is ruled unconstitutional. A lot of the questioning, finding a line after matching funds are gone as to what exactly the play of government is. So I think that's why we're very confident here, is the line of questioning seemed to really revolve around what's going to be left and what's left, where is the line for constitutionality. I didn't see a lot of questioning by any of the justices that left us any thoughts that matching funds is going to remain for much longer.
And I would like to point out that this case is not about public financing. Nobody is saying in this case that the government cannot provide an alternative for people who wish to run using public financing. But what we're saying here, and what the First Amendment recognizes, is that in providing that alternative, the government cannot burden the free speech and free expression of individuals in doing so in order to incentivize people to participate or disincentivize people to speak more than the government prefers.
To borrow from the hypothetical the court used, what matching funds is like for free people who want to exercise their free speech in Arizona would be like the government paying the opposition in this case to write the briefs against the petitioners.
You want to say who you all are so we all know?
My name is Shane Wikfors. I represent the Arizona Independent Expenditure Committee called the Arizona Taxpayers Action Committee. And we clearly brought this challenge because we believe that our free speech was being quashed in a way when government essentially came in and subsidized candidates that we didn't agree with. And so our donors, it's in our best interest to look out for our donors who obviously want to be a participant in Arizona elections, and what resulted was they decided that it was not worth the burden to be involved as a result of this law. So that's why we're a part of this. We see that the justices, several of the justices were able to differentiate between what was actually going on, and in fact saw that leveling the playing field was a prominent part of what this law does, which we believe is unconstitutional.